Senator Hanson.
Thank you very much. Well, I rise to speak to the Family Law Amendment Bill. This legislation gives effect to several recommendations I have made as Deputy Chair of the Joint Select Committee on Australia's Family Law System, established after I lobbied then Prime Minister Malcolm Turnbull. There is broad support for some of the changes contained in the legislation, and I will refer to these later. Some of them are changes I've been advocating on the Select Committee and in public for many years. No one could argue against focusing on the best interests of children involved in family law cases. However, by removing the presumption of shared parental responsibility as a factor that must be considered in deciding custody arrangements, this legislation could well have the opposite effect. This presumption has never been about equal time in child custody arrangements. It doesn't matter that it may have created this perception. The court and the legal profession have a duty to explain it and make sure parents seeking resolutions in or outside of court do not labour under this misunderstanding. If they have not, then the failure is theirs and not that of the legislation. The presumption has always been about recognising the truth, that when you are responsible for bringing a child into the world with someone else, you share equal responsibility for the child's care. This shouldn't be a controversial principle, not if you think people should take responsibility for their actions at any rate. The introduction of the shared parental responsibility presumption was almost unanimously supported by this parliament in 2006. The Gillard Labor government kept the presumption in place when it modified the legislation in 2011. In 2020, Labor in opposition tried to remove it and failed. Today, they're seeking to remove it again despite expert warnings they should retain it. Former Family Court Judge Professor Richard Chisholm warned the abolition of the presumption should not inadvertently bring Australia back to a time when mothers were granted primacy in court battles. He further warned that removing the presumption would bring back the old 80-20 model that underpinned an assumption that mothers would be responsible for the bulk of childcaring duties following a relationship breakdown. He recommended the legislation should stress the importance of continued involvement by both parents. Quote, "It is important for the majority of children to continue the involvement of both parents after family separation. It is right that the legislation should stress this because it seems it was once assumed that it is enough for children to have one involved parent with the other, typically the father, providing financial support and weekend entertainment." Unquote. In his submission on the exposure draft of this bill, Emeritus Professor of Law at the University of Queensland, Patrick Parkinson, AM, said the government had not made any reasonable case for what he called radical changes to the philosophy of Part 7 of the Act. He warned of increased litigation, increased difficulty in resolving disputes and increased costs for parents and courts. Professor Parkinson noted these changes would unsettle the law and represented a fundamental change to the values that are expressed to underlie the family law system. He noted an evaluation of the 2006 family law reforms by the Australian Institute of Family Studies, or AIFS, found the philosophy of shared parental responsibility is overwhelmingly supported by parents, legal system professionals and service professionals. For him and for me, the most alarming aspect of the bill is the removal of this philosophy. The bill effectively deletes it, removing the need to ensure that children have the benefit of both their parents having meaningful involvement in their lives to the maximum extent consistent with the child's best interests, that children have the right to know and be cared for by both their parents, and that children have a right to spend time on a regular basis with and communicate on a regular basis with both their parents and other people significant to their care, welfare and development, particularly grandparents. that parents jointly share duties and responsibilities concerning the care, welfare and development of their children, and that parents should agree about the future parenting of their children. I think it's arguable that this legislation contravenes the United Nations Declaration on the Rights of the Child, which Australia signed and ratified in 1990. Article 7 of the Declaration says, "The child shall, as far as possible, have the right to know and be cared for by his or her parents." Article 9 says signatory nations shall respect the right of the child who is separated from one or both parents to maintain personal relationships and direct contact with both parents on a regular basis, except if it is contrary to the child's best interests. Article 18 says signatory nations shall use their best efforts to ensure recognition of the principle that both parents have common responsibilities for the upbringing and development of the child. I think family lawyers might want to brush up on the constitutional law, and fit parents unduly denied access to their children might want to consider approaching the High Court to challenge the validity of this legislation. And I have heard that parents are considering taking on a class action with regards to this. Evidence presented to the Joint Select Committee included an analysis compiled by the North Dakota and Oregon State Universities, presented as evidence to the Joint Select Committee inquiry, concluded that fathers really do matter. It supported the importance of fathers being able to connect with their children through shared activities. It confirmed that fathers play an important role in the lives of children and the need for positive connections contributing to a child's well-being. It analysed data which showed that where there were positive connections and communication with their fathers, children were much less likely to have problems later in life, and it affirmed the need for courts to consider the positive contributions fathers can make to their children's lives. I note the bill still requires courts to consider the benefit to children of maintaining a relationship with both parents, but importantly removes the term meaningful as a deceptor of the relationship. Why? Because the Albanese government has adopted the broken philosophy promoted by women's advocacy and domestic violence groups that children are only safe from violence in the care of their mothers. This denies evidence that women are more likely to commit violence against their children than their fathers. There have been several high-profile cases in Australia documenting this fact. It denies evidence that 25% of reported domestic violence is committed by women. They're effectively saying that shared parental responsibility makes it easier for violent men to insist on a post-separation parenting role. As Professor Parkinson points out, however, this is not supported by the evidence. In fact, the AIFS study found that many more fathers than mothers were concerned for their child's safety and shared parenting arrangements. This was borne out in evidence provided to the Joint Select Committee inquiry into the family law system. Ultimately, the evidence was clear: the system is already heavily biased against fathers. The removal of shared parental responsibility increases the possibility of entrenching this bias. The demonisation of Australian men is unjustified and needs to stop. Men are already overrepresented in homelessness, in jobs with higher risk to safety, as victims of violent crimes, and tragically in suicides. Many of these studies are associated with unfair and unjust family law outcomes from a system biased against fathers. The removal of shared parental responsibility carries a strong risk of even more unjust outcomes. In principle, I support some other parts of this bill. In the Joint Select Committee inquiry, I argued for and support in particular the emphasis on the wishes of the child and the requirement that independent child lawyers, or ICLs, be required to learn and advocate the child's wishes. I have been advocating this for many years, that the child's wishes, where possible, are objectively considered by the courts. However, to do this in such a way that the wishes of children as young as 5 are objectively presented to the court will require specialist training for ICLs. I also support the mechanism aimed at preventing the manipulation of the family law system what this bill considers to be harmful proceedings. This is also something I've been advocating for many years, preventing people from using the system to attack or punish an ex-partner during acrimonious separations. However, it must be fairly and equally applied to both mothers and fathers. My fear is that it won't be fairly applied. Advocates for these changes, and I note Senator Rice's telling contribution to this debate, focus only on the rights of women and children and ignore the rights of men. That is the fear of good fathers mired in the family law system, unfair outcomes for them based on the violent behaviour of a few. A lot of women also provided evidence of bias against them in the system, but in my opinion it is mainly men who are denied fair access to see or spend time with their children. There was clear evidence presented to the Joint Select Committee that many mothers made unfounded or deliberately false allegations of violence against fathers. 90% of parents alleging child sexual abuse in contested hearings from 2012 to 2019 were the mother. In 90% of these hearings, the judge found no risk of sexual harm to the child or children. 90%. In 25% of these cases, the allegations were found to be deliberately misleading. In another 46% of these cases, the allegations were mistaken. In 88% of these cases, the allegations were not believed by the judge. In 62% of these cases, the judge awarded shared parental responsibility or sole responsibility to the parent against which the allegations were made. And in 66% of these cases, orders were made increasing parenting time with the parent against which the allegations were made. This was confirmed by former Family Court Judge Justice David Collier, who said allegations of child sexual abuse were being increasingly invented by mothers to stop fathers from seeing their children. He said, "I'm satisfied that a number of people who have appeared before me have known that it is one of the ways of completely shutting husbands out of the child's life." In principle, I also welcome the government's support for extending the Lighthouse project, but I am disappointed that the sensible changes I've proposed to the child support system are not reflected in these reforms. As Professor Parkinson has noted, the current system provides perverse incentives for primary caregivers to resist children spending more time with the other parent to avoid a reduction in the child support obligation. My recommendations would remove this incentive and make the system fairer and simpler, and for the record, I'll list them. Ensure parents aren't left with incomes below $27,000 per annum. Access salaries on a 38-hour working week. Base child support on the number of children at the time of separation, not on additional children to other partners. Assess residential costs individually and include family tax benefit in assessing incomes. Exclude lump sums such as work cover, TPI or superannuation payments in assessing incomes, and have child support payments paid to a separate child support account subject to scrutiny by Services Australia to ensure all child support is going to support children. Since being elected, I've always fought for the law to treat Australians fairly and equally, regardless of gender, race, religion or other identities. This has been my motivation for reforming Australia's broken family law system. It was my hope the Joint Select Committee inquiry would generate the evidence to back these reforms. The inquiry certainly achieved that, but I didn't count on the perverse motivations of others in the committee to drive the system into potentially greater conflict and unfairness. Families experiencing the system, both now and in the future, have my profound sympathies because the chance of genuine reform has been squandered. I will never stop fighting for fairness and for the best outcomes for children and families in the Australian family law system. I will be moving amendments to this bill on domestic violence requiring proof and not just allegations, children's lawyers requiring further training, and I would like to see a sliding scale or a cap on legal costs. Too many parents out there are suffering because of this, and this is a backward step, as I've said. This is just hurting those fathers that are hurt more so from not being able to see their children for no reason whatsoever, and you're going to keep it going in the court system. These lawyers are going to make a lot of money out of this, and I feel sorry for the children. You're not considering the children at all. You're a selfish bunch.